This is Bill Erhard at Estate and Elder Law Services. Let me speak to you for a moment about powers of attorneys. If we're going to manage incapacity, we almost certainly need a power of attorney. A power of attorney is when you give authority to someone else to manage your property. A durable power of attorney is a power of attorney that is effective even when you are incapacitated. In Delaware, there are two types: a power of attorney that is effective immediately when you sign it, or a power of attorney that springs into existence when you're determined to be incapacitated. If you have a power of attorney, most of the time, your loved ones can avoid guardianship if you become incapacitated. Powers of attorneys are very technical documents governed by very strict rules. Powers of attorneys vary slightly from state to state. One of the major issues that we have with powers of attorneys, not just in Delaware but across the country, is that banks and financial institutions have their own rules governing powers of attorneys. There was a May 13th, 2016 article in the New York Times about how often banks and financial institutions restrict or reject valid powers of attorneys. There are better ways to manage your assets than using powers of attorneys, and we'll talk about that next.